seconds to go. Start. The police team arrived with the review petitioner, there was firing upon the police team as stated in circumstance G in paragraph 182. Stop. After the person concerned named Abu Samal alias Faisal died in the encounter, certain firearms and ammunition were recovered. Stop. The submission that such recovery of ammunition or the encounter of Abu Samal could not be associated with the disclosure statement of the review petitioner is not quite correct. Stop. We therefore reject both the grounds taken in B and C as referred to in para 12 supra. Stop. Para. We now turn to the last ground regarding possibility of retribution and rehabilitation of the review petitioner. Stop. On this issue, the response of the state in its written submissions is as follows. Para. The petitioner, admittedly a Pakistani national, has been convicted inter alia under section 121, 302, 120b, 121a, 181 and 353 of the Indian Penal Code, section 25 of the Arms Act, section 4 of the Explosive Substances Act, section 14 of the Foreigners Act, for waging war against the government of India and committing murder in pursuance thereof. Stop. This honorable court has taken the view that the cases of such nature, involving acts of terror which challenge the unity, integrity and sovereignty of India can only be adequately compensated by awarding the death sentence. Stop. Reference in this regard is drawn to the judgment of this honorable court in State of NCT of Delhi versus Navjot Sandhu 2005-11 SCC 600, the Parliament attack case, where it was held, para. In the instant case, there can be no doubt that the most appropriate punishment is death sentence. Stop. That is what has been awarded by the trial court and the High Court. Stop. The present case, which has no parallel in the history of the Indian Republic, presents us in crystal clear terms, a spectacle of the rarest of rare cases. Stop. The very idea of attacking and overpowering a sovereign democratic institution by using powerful arms and explosives and imperiling the safety of a multitude of people's representatives, constitutional functionaries and officials of the government of India, and engaging in a combat with the security forces is a terrorist act of the gravest severity. Stop. It is a classic example of rarest of rare cases. Stop. Para. The gravity of the crime conceived by the conspirators with the potential of causing enormous casualties and dislocating the functioning of the government as well as disrupting the normal life of the people of India is sometimes which cannot be described in words. Stop. The incident, which resulted in heavy casualties, had shaken the entire nation, and the collective conscience of the society will only be satisfied if capital punishment is awarded to the offender. Stop. The challenge to the unity, integrity and sovereignty of India by these acts of terrorists and conspirators can only be compensated by giving maximum punishment to the person who is proved to be the conspirator in this treacherous act. The appellant, who is a surrendered militant and who was bent upon repeating the acts of treason against the nation, is a menace to the society and his life should become extinct. Stop. Accordingly, we uphold the death sentence. Stop.